SJC-9999, Commonwealth versus Johnson.
Mr. Malkovich, good morning.
Good morning. May it please the court. Michael Malkovich representing the defendant, Curtis Johnson. Currently, Umar Salahuddin is his name.
Sorry, say that again?
His name now is Umar Salahuddin. I wanted to address particularly three of the issues that are raised in the brief. I'm not abandoning any of the other issues, but the ones that I think should be looked at in particular. The first issue has to do with the invocation of the Fifth Amendment right to not testify for the witness Jani Bynum. This case was retried. Well, it was tried initially in 1992. It was retried in 2003. In 1992, Jani Bynum, who was a peripheral witness, had very little information about the case. She was the woman who spoke with the defendant after the incident, and he purportedly made admissions to her of having done something bad. Her son was also one of the suspects in the case.
It's more than that, isn't it? I mean, right? She's the one who directs them to the restaurant too, right?
Well, she
directs,
does.
So she tells them to go to this particular Chinese restaurant to pick up food, right?
That's correct.
And they don't, and then they come back late. She's aggravated because it takes them a long time. And then she has a detailed conversation. It's a two-part exchange, right? With the defendant. One, I did something bad, and then there's an even more incriminating statement, right?
No, I think that's the most incriminating statement. There was a statement about having spit on the owner, having gotten into an argument, but that's pretty much it. It's pretty vague.
Isn't that's really important, right? Because it identifies not only that he's at the scene, but that he's done just the thing that set off the whole furor, right?
That's correct. It is a very incriminating statement. And Ms. Bynum's own son was also arrested. In fact, he was arrested right after this incident. And when she gave her statement to the police, he was in custody for that. There was evidence that, they brought the food back. They ate the food. These statements were made. The defendant disappeared for the night. He returned in the morning, told her that he was heading back to Springfield from Worcester. She was surprised because the plan was they were going back later, but he wanted to leave, and he did. She ran into him a couple of days later in Springfield, and there was a conversation with him where she asked him if he did it, and he said, no, he didn't. And she said, well, somebody did, and I don't want it to be my son who's blamed for this. So she had clearly a concern about her own son, and that was an interesting issue. She became sort of hostile in her relationship with the district attorney's office. At one point—
part of the voir dire, the cross-examination, the statement about not wanting her son to get pinned for this?
That never came in. The jury didn't hear anything that had to do with her motives in this particular case.
But when there was a voir dire of her?
Well, the voir dire, it came out in the voir dire.
Okay.
But the thing that's important to realize, if you look at how tightly the judge controlled this voir dire, he said the only issue is the voluntariness of these statements. And there were several times when he stepped in, whenever the attorney would veer off, he'd say, this is not what we're here for. We just want to know, we're focusing on these statements. So none of that stuff was permitted to be really explored. Some of it did come out, but what was ultimately used at trial, because the Commonwealth raised the question that there was discrepancy between what she'd said in the grand jury, what she'd said in this voir dire and what she had also indicated to the district attorney informally. They raised this question of perjury
But
back
what
then.
about the voir dire as to whether or not he, the defendant, even made the statement? Didn't the defense attorney cross-examine on that?
Well, he made the statement, but that was sort of a necessary thing because the whole issue was what was his condition when he was making these statements. So
Right.
yes, he made a statement, but there was never a challenge to whether she heard this statement correctly or whether she had any reason to fabricate it. I mean, she was certainly in a position, if she was concerned about her son, she was certainly in a position to say something that this defendant admitted to for the purpose of helping her son. But again,
That came out in the voir dire, you said.
I'm sorry?
But that did come out in the voir dire.
It came out in the voir dire, but never was presented to the jury because what was presented was a very stripped-down version of what she testified to. It eliminated any of the references to inconsistencies in her statement. If I might get a glass of water, I'm getting a little dry. It eliminated any of those inconsistencies and basically left nothing for the jury to evaluate what this witness's credibility was, whether she had any motives or anything of the sort. And what's significant about that, and I quoted this in the brief, was that the prosecutor described her as one of the worst witnesses he's ever seen and basically said she had pages and pages of lying and dodging and doing everything. He was disgusted with the way that she testified. But again, the way she comes across at trial is everything is completely lined up. There's nothing in there that suggests any inconsistencies or any problems
So
with her testimony.
what should the judge have done here exactly? If the judge had done this correctly, I take
Well,
it,
I'm sorry.
go ahead, because we got two issues. One, whether she was properly allowed to invoke the Fifth, and secondly, how to treat, the prior testimony. So if the judge is correct, what should the judge have done in this case?
He should have not allowed her to invoke the Fifth Amendment in the second trial because the only issue that was raised in the first trial was perjury. Now we're 11 years later. She is not subject to perjury for statements that she made in 1992, and the law doesn't give her free rein to make false statements now in 2003 and be protected.
Even though you've made the point that she's really working hard to keep her son out of trouble here, so she's not an accessory after the fact in this, and she's not vulnerable on those grounds given her great concern about her child and sort of pressuring conversations that you just recounted?
I think the suggestion in 2003 that she might be brought in under those possible charges was completely unfounded, and we have the prosecutor with full...
Why, just what you, but if she's doing what you sort of talked about a couple of minutes ago, why isn't she vulnerable to this?
Well, because that's not an accessory after the fact.
Well, if she's trying to manipulate what people say to protect her son, why is she not? I mean, I haven't looked at the elements of accessory after the fact, but it sounds like she's getting herself into trouble here besides perjury.
Well, let's put it this way. If she is saying that she heard this defendant make these statements, I don't know if that rises to the level of accessory after the fact, but in any event, it would be a relevant issue to cross-examine her on.
But it doesn't have to. All it has to be is a link in the chain that might suggest that there might be a joint venture as it relates to accessory after the fact. I mean, it's just a link in the chain. We're very protective of people's right against self-incrimination.
And I understand that, and I understand that's what the Commonwealth argues, but there's also the question of whether by testifying voluntarily before the grand jury and during this extensive voir dire, she essentially went through everything that she had done she's waived that right, that Fifth Amendment right. She voluntarily testified, and the case law says that when a witness voluntarily testifies about a fact,
Commonwealth versus Martin seems to, I don't know if that came up in the brief, I can't remember, but Commonwealth versus Martin seems to go the other way on that.
well, the question is if she has testified fully, get my reference to the case.
Yeah, I think that case law says in the same proceeding.
And
You can't
that,
basically start talking and then stop in the same proceeding. But if you spoke in the grand jury and you want to take the fifth at trial, we have a different standard.
well, I would argue that the voir dire is the same proceeding, and the case that I would cite in support of that,
But the second trial is not the the second trial has got to be separate, isn't it? Can't be the same proceeding at that point.
I cite the case, which I didn't put in my short outline here, but if it will, I can submit that to the court afterwards if that is a significant issue. But,
Sounds like it might be.
okay.
So was there a request by defense counsel for an in-camera hearing of her in the second trial, just to test whether indeed she had a Fifth Amendment right?
Trial counsel did a pretty good job of arguing why she did not have her Fifth Amendment right. He asked the judge to inquire, because there was also a suggestion made by the Commonwealth, again with no foundation, that maybe she had left the Commonwealth so that the statute of limitations was told during that period of time. And counsel said, can we inquire? And the judge said, no, we can't do anything to inquire at all. And I suggest that's not the law, that the law says clearly that it's simply not the bare assertion by the witness or her attorney, but the judge has some duty to ensure that that is a properly invoked Fifth Amendment right. But this judge wouldn't touch it at all, and I think that had he done that, this would be a lot clearer.
So say you lose on the first part of this. How about what should the judge have done differently in regard to the testimony he allowed or she allowed in?
Well, I think that unfortunately the way that it was handled, they had gone through the testimony at the first trial, a different defense attorney and a different prosecutor, and they had identified what they felt was the appropriate redacted testimony to present. And there was some modification of that at the second trial, but it was pretty much accepted almost the same as it had gone in the first trial. So
But it had been worked out in the first trial what was permissible to say?
that's
And-
correct.
And so now you're saying that the judge erred by rejecting the consensual agreement on how to treat this?
Well, I think that the problem was that it intertwined some of the information that we would want to have come out in the cross-examination intertwined with other statements that the witness said that the
Could you
defendant.
give me one example of that, if you don't mind, of how, because you can impeach an out-of-court declarant just as if they were on the stand.
I don't suggest it was a good reason. I would,
No, I'm just saying, just because the out-of-court declarant's not there, you can impeach, the law of evidence allows you to impeach that out-of-court declarant as if the out-of-court declarant were on the witness stand.
I would agree with that, and I believe that the jury could have been presented with portions of that testimony that were suggesting changing her statements or suggesting that she had other motives. There's nothing in the record that explains why defense counsel didn't go that way. I would suggest that that could have possibly been a way to at least limit some of the harm to that. But I would still push primarily on the issue that I don't think that in light of the evidence that the Commonwealth had, that there was any real sufficient basis for implicating this witness who knew so little about the case and had really no close relationship with this defendant, and certainly there was no activity that she engaged in that would have suggested that somehow she was helping him or doing anything more than wondering, what had happened and why are you leaving so soon. The fact that her son was arrested and might influence her ability to be honest with what was said, I would suggest that doesn't rise to the level of accessory after the fact, joint venture, conspiracy, or any of the things suggested by the prosecuting attorney.
So let's assume for the moment that you're right. Is there a proffer as to what prejudice would have arisen from what would have happened had she indeed been required to testify?
Well, first of all, this was the only admission that the Commonwealth had. Identification was an issue in the case, and having this defendant make a statement such as he did was a fairly significant piece of evidence.
But that would have come in if she testified. So your claim is that she should have been required to testify and that she could have then been impeached with regard to what she did say. But what is the impeachment that you're presenting to us which we can look at and say, oh, my dear, that would have thoroughly impeached her testimony?
Well, it would have been all of the things that the prosecuting attorney found in the inconsistencies that made him conclude that she was one of the worst witnesses that he had seen. So there were a lot of inconsistencies. There were points at which she refused to testify. There were points at which she retracted statements. One of those statements, going back to the question that you raised, Justice Lowry, was at one point there was a conversation with this defendant about somebody shooting a person, and that was in the discussion in the voir dire that was retracted or redacted from that, because that was obviously something that would have been potentially prejudicial. But I guess the point was that the jury needed to see this witness to understand what kind of a witness she was and what her potential motivation was. And that, I think, could have raised some serious questions about the accuracy of her recounting this admission.
So as it relates to that issue, if the judge made the right decision relative to the Fifth Amendment, the voir dire is read into evidence, and there's not impeachment evidence to cross-examine her that could have been used, then we'd look at that as substantial likelihood, right? So you'd be at the same
Probably.
standard.
Yes, I would
So
agree
you'd
with
be
that,
at the
Your
same standard anyway.
I would agree with that.
Okay.
Now, if I may move on, is that the issue concerning the newly available evidence? I know that this is an issue that has been before this court repeatedly in the last couple of years, and I understand that the court has identified age 18 as the cutoff point for considering when a life sentence without chance of parole is appropriate. And it's interesting, and in Garcia, most recent case that the court heard, I believe, was a request to have the court consider whether they should extend that protection to a defendant who's over the age of 18. And the court acknowledged that this was an evolving area of the law. It had a lot to do with the science and information that was coming in, but they felt that on that particular case, they didn't have the kind of record that was needed to look at the issue clearly.
Well, but counsel, evaluating that, don't we also should we also take into account public safety? And if you look at the defendant's psychological records, he has some very serious violence issues. So how does that affect your analysis?
Well, I think the public safety issues, Miller addresses that in a way. They say that it's not the severity of the crime that's really the issue. It's the question of where is this person's level of development.
Read his psychological report, you see the development is very violent, right?
Absolutely, at that time. And his impulses are out of control. He has a tendency towards violence. In that sense, you have a very unusual in that you have, I think, that much of a record prior to the incident and the warnings about how this person needs to mature. They need maybe a secure facility until he does mature. Afterwards, you have evaluations right after the incident that are consistent. And now, many years later, two psychologists who review him and can compare how he has changed as he's matured. And I think in some ways it illustrates exactly what Miller was talking about, which is that while the characters and personality is forming, this is when it's unreasonable to make a decision that this is a hopeless case, that we should not have any chance for letting this person out. As far as public safety goes, that decision to let him out depends on what the parole board decides when they review the case. In this instance, he has no chance of ever showing that, and I would suggest that where he is put in that position as a young person, shouldn't he at least have the opportunity to see if, in fact, this was a developing personality that has changed?
But Miller speaks of all juveniles, and we've had other cases, and I'm sure we'll get another case soon, which says all 18-year-olds also suffer from this. You're making a separate argument. I gather you're saying that we should evaluate the individual and say, well, this particular individual is immature, and therefore, even if he were 18, or for that matter, if he were 21, we should treat him as if he were under 18. Is that what you're asking us to do?
Oh, absolutely, not necessarily as a rule per se, but that there ought to be consideration for a case as extreme as this, where a couple of the psychologists said, his maturity level was near 7 or 8 years of age. So he's clearly way below the maturity age of 18.
So that could happen. We've got individuals for various reasons who could be 24, 28, 40, whose maturity level is that of a 14-year-old. You would say that would apply to them too, because we look to not to the chronological age, but to the age of maturity?
Well, I think that it's something that ought to be considered, and the court doesn't have to make a rule either. The court has the discretion to factor that into everything else in the case and make a decision as to whether this is an individual who should ever have a chance to see the parole board, and reducing it to second degree.
Okay, so you would say
accomplish that.
it should be part of our 33E analysis.
I agree. It could be that as a way to address this issue without necessarily trying to create a rule that maybe the court feels is opening the door for more than you wish to do.
With the chief's permission, could you at least tell us what your third issue was? You didn't get to it.
Well, the third issue was tied to that, and it was simply I kind of blended those two in. The newly available evidence would have provided a defense of non-criminally responsible based on the fact that a personality disorder was excluded in that trial, because at that time it did not qualify as a major mental illness. 2013, the DSM-5 issued a correction that did not separate out personality disorders from major mental disorders, so this would have been an available defense. That was actually the second issue that I was heading towards, and so he didn't have the ability to present that defense. In fact, the psychologist who was hired in the first trial said, no, you don't make it at that particular defense. It doesn't work because personality disorders don't qualify for bringing that kind of defense.
But what do we do with the fact that in his first trial, he did give a criminal responsibility defense, and in his second trial, he chose not to? So you're asking us to saying that counsel was ineffective for failing, or that there's newly discovered evidence that antisocial personality would be enough for a criminal responsibility defense, but the defendant said, I don't want a criminal responsibility defense, I want to pursue a mistaken identity defense.
Well, at the time, it wasn't, in 2003, under the DSM-4, I believe was in place at that point. Personality disorder was not categorized as a major mental disorder, so it really wasn't available. And so it's like any other development in science that comes up later. It's not available to really seriously entertain.
Okay, thank you.
Thank you.
Ms. King.
Good morning. May it please the Court. Michelle King, Assistant District Attorney for the Commonwealth. The Commonwealth requests that you affirm the first-degree murder conviction of Curtis Johnson for the following reasons and those set forth in my brief. Janie Bynum was, in fact, properly allowed to claim her Fifth Amendment privilege at the second trial. In this case, and as constitutional provisions provide, the Fifth Amendment is highly protective of a witness's right to not incriminate herself. It's not a balancing test that's conducted by the court. We don't weigh the defendant's rights to cross-examine against the witness's rights under the Fifth Amendment. Rather, the judge must look at whether it's perfectly clear that the proposed testimony could not possibly incriminate the witness in that regard. Now, at the second trial, in this matter, the prosecutor, upon request from the trial judge, put on the record in open court his belief that Ms. Bynum was subjected to exposure for criminal charges in the area of accessory after the fact, joint venture, conspiracy, and possibly harboring Mr. Johnson after he committed the crime. Counsel was appointed for Ms. Bynum at that point. He had consultation with her, and he came back and represented to the court that based on the confidential disclosures that she made to him, she did in fact have exposure with regard to the issue of joint venture and conspiracy. Now, the touchstone of whether or not a judge makes a proper determination with regard to a witness being allowed to incorporate the Fifth Amendment is whether or not the judge made an informed decision and whether or not he or she looked at all of the things that were possible. In this case, the trial judge not only took the prosecutor's assessment of the charges that Ms. Bynum could possibly be subject to, he also, again, heard from the attorney for Ms. Bynum, who represented that she had made confidential disclosures to him that would suggest, again, that she could be open to exposure. But not only that, the trial judge in the second trial was provided with a transcript from the first trial that really gave him the flavor of how this Fifth Amendment privilege came about. And he stated on the record that he, in fact, had read that transcript that was provided to him. And if you look back how the Fifth Amendment privilege came to be in this case, Ms. Bynum was at the voir dire, giving testimony at the voir dire, and the issue was, in fact, whether or not the statements made by Mr. Johnson were involuntary due to intoxication. During the course of that, however, defense attorney was provided the opportunity not only to ask Ms. Bynum questions about the circumstances surrounding the testimony. In other words, was Mr. Johnson intoxicated, level of intoxication, things like that. But he was also provided the opportunity to ask her questions about the substance of the statements given by Mr. Johnson. And two of those statements in particular, one on the subject of what Mr. Johnson had said to her that he had done. And that testimony I set forth, or the questioning I set forth in my brief at pages 36 to 37.
Your brother, and I haven't read the transcript yet, but your brother says the judge at the same time is limiting the questioning. Is he doing that as well?
Well, there was no doubt that the judge at the voir dire tried to focus everyone's attention on the issue of whether or not Mr. Johnson was so intoxicated that his statements were involuntary. There's no doubt that there was absolutely a focus on that. However, I would suggest to you that there was quite a bit of questioning on the part of Mr. Johnson's lawyer with regard to the substance of the statements, and the substance of the statements in particular, whether Mr. Johnson said, I did something bad, and whether or not Mr. Johnson made an admission that he spit at someone at the restaurant. The attorney for Mr. Johnson was allowed to, was given quite a bit of leeway, in fact, to question Ms. Bynum on those issues. And so it was during the course of that counsel for Mr. Johnson was the person who requested that Ms. Bynum be appointed counsel and that she be allowed to assert her Fifth Amendment privilege. And there was quite a bit of discussion about it. I'm not sure if you have the transcripts from the first trial or not, but it encompassed quite a number of pages with regard to, at the time, whether or not Ms. Bynum had a Fifth Amendment privilege at that time. It was ultimately determined that she did, and then her testimony from that voir dire, of course, was read at the second trial.
At the determination of whether or not she had a Fifth Amendment privilege, was there any proffer as to the issue of whether she had harbored the defendant at any point as it related to accessory after the fact?
There wasn't a specific proffer, Your Honor, but based on the testimony of Ms. Bynum at the voir dire at the first trial, it was very clear the particularized area in which she had not been questioned. In other words, she was questioned pretty significantly at the voir dire about the time period when Mr. Johnson and the other gentleman came back from the restaurant. She was questioned about having sent them out to the particular restaurant, that they came back late. She was questioned about the statements that Mr. Johnson made to her. The area that she was not really allowed to delve into, however, was the area of how Mr. Johnson came to leave Worcester early, what bus he took, who took him there, with any great regard, the interaction that she had with him a few days later back in Springfield. There was certainly some discussion about Ms. Bynum's desire to insert herself into the process for the benefit of her son. There was some information about that, however, that was not fully explored. So when you look at whether or not Ms. Bynum was allowed the opportunity to make a blanket assertion with regard to her Fifth Amendment rights, Martin is pretty clear on that it's either particularized questions or an area of discussion that the witness is prohibited from talking about. Here, Ms. Bynum was clearly not questioned about this post-shooting behavior on her part or the part of Mr. Johnson, how he came to get back to Springfield early, why the plan that they had devised the day before in terms of returning to Springfield, why that wasn't followed. None of that questioning was allowed, and that is the area where Ms. Bynum had exposure in terms of her conviction for conspiracy, harboring, joint venture.
The harm that the defendant is claiming here, though, is that the jury really couldn't get a feel for potential impeachment, motive, issues like that, because she wasn't on the witness stand. And, you can impeach an out-of-court declarant under Mass Cite Evidence 806, but you've got to have something that you can put in to cross-examine. It might be that they didn't have anything to put in to cross-examine to show either testimonial faculties or that, she had a bias.
Well, there was some testimony, Your Honor, again, about her motive for maneuvering things around in terms of her son's involvement. And that did come out at the voir dire, and certainly defense counsel could have attempted to, impeach her by way of that. What I would suggest to you is that Ms. Bynum's testimony in regard to what did come in from the voir dire is essentially corroborative from a plethora of identification information that we had, evidence that we had at trial. Mr. Johnson's statements, inculpatory statements to Ms. Bynum, I did something bad and I was the person who I spit on somebody at the restaurant, had great level of support in the trial record. There were 5 witnesses who testified who essentially all testified to the same thing. You have Mr. Tony, who was also shot in this case, testified that, well, a number of the witnesses all testified that there were 4 men, 3 Hispanic and 1 black man. Number of the witnesses, 3 of the witnesses, I believe, testified that it was the black man inside the restaurant who spit at the owner. They also testified that it was the black man in baggy shorts who was the shooter.
But it's a stranger ID, right? All those are stranger IDs. I understand they're all corroborative of each other, but it is pretty important testimony when he admits to being the person who spat on the person, right? Yeah.
I'm not saying that it's not important, Your Honor. Certainly, it's further corroboration that he made that statement. And I would agree with you that it's a stranger identification, but when we talk about stranger identification, sometimes it's a fleeting opportunity. In this case, it was much more than a fleeting opportunity to identify the defendant. There was an initial incident that happened inside the restaurant where at least 3 of the witnesses had an opportunity to view the defendant and his friends inside the restaurant. And then there was a second incident that included the shootings that occurred outside the restaurant. So this wasn't a drive-by, stranger identification. It occurred over a significant period of time, and all of the witnesses' testimony corroborated each other in substantive fact. With regard to, if there are no further questions on...
Can I ask about, I'm trying to figure out whether we need the transcript from the other trial. So we've got a lack of criminal responsibility in the first trial. The second trial, we don't have a lack of criminal responsibility, but the DSMR standards have changed in the interim. Can we evaluate this issue without the earlier trial transcripts?
I'm sorry, Your Honor, could you?
I take it that the argument is that they should have done criminal responsibility again, lack of criminal responsibility again. Do we need to see sort of how that played out in the first trial to evaluate whether it was ineffective not to do it again, given the change in the DSMR?
The record was actually quite clear, Your Honor, that Mr. Johnson was not at all obviously happy with the way his first trial went because he was convicted of first-degree murder, and that he wanted to pursue something quite different in his second trial. And there was, I believe, an affidavit that was submitted in the trial court from his attorney that said that very thing. Now, at the motion for new trial hearing, the motion judge had the opportunity not only to hear from defendant's expert witness, but from the Commonwealth's expert witness, who unequivocally said that personality disorder does not qualify as a mental defect in terms of a criminal responsibility defense. And so I would suggest to you that not only did the defendant...
Second trial or the first trial?
This was a motion for new trial hearing that was held in front of Judge Tucker, whereby we had expert witnesses for the defendant and also expert witnesses for the Commonwealth. And the motion judge made findings that the defendant's mental disorder did not qualify as a defect in terms of criminal responsibility. And that was a determination that he made after a full day of testimony from expert witnesses.
Do we have cases on dealing with this particular disorder and how it plays into, this issue? Do we have any cases describing this disorder as not meeting the definition, the McCool standard or whatever it is?
Not that I'm aware of, Your Honor, but admittedly, I didn't research that issue.
Did the DCM change and say that antisocial personality disorder is a mental disease or defect?
The DSM changed, but not to the effect that it qualified a personality disorder as qualifying as a mental defect. No, the DSM does not say that. And that's why we had the expert testimony back and forth between the Commonwealth's witness and the defense witness on that particular issue. And Commonwealth's witness, Dr. Saleh, was was quite powerful in his assessment. In fact, let's see if I have it. I believe it was the motion hearing from June 2nd that Dr. Saleh, it was it that I cited in my brief. Dr. Saleh talked at length about his assessment of Dr. Rin's assessment of the situation. So the motion judge had all of that information before him when he determined that the defendant's antisocial personality disorder, in conjunction even with alcohol, did not qualify as a mental defect.
So I have a completely different topic question. The closing argument where the prosecutor says that the defendant's DNA is on the pillowcase. Do I have that right?
The wrong case.
Wrong case?
Wrong case.
That's busted. Never
Our
mind.
next case.
Never
Oh,
mind.
thank God, Your Honor. I was a little confused about the pillowcase.
Stick around, you'll hear about pillows.
If there are no further questions, I'll rely on my brief.
I've got one last question. Was he entitled to a Martin hearing?
Your Honor, Martin is very clear that that is, a Martin hearing is permissible but not required. And in fact, the preference is to have the reason for the invocation of the Fifth Amendment to be placed in open court. And so I would suggest to you that defendant was not entitled to a Martin hearing, and in fact, what was supposed to happen exactly happened in this case. The trial judge asked the prosecutor to put his reasons on the record as to why Ms. Bynum had a Fifth Amendment privilege. Ms. Bynum's attorney also put on record, and the trial judge made an informed decision based on those representations, but also his review of the transcript from the first trial. So no, the defendant is not entitled to a Martin hearing, Your Honor.
Okay, thank you. And we'll take our morning break.
Thank you.